eating that delicious looking dessert, please, by all means, you guys enjoy as we chat up here and hopefully educate you on the world of class actions and bankruptcy and that intersection. Feedback. I'm Gina Passarella. I'm editor-in-chief of Global Legal Brands at American Lawyer Media. And I'm going to try to do very little talking today because this is far from my area of expertise, though I have learned a tremendous amount in just a little bit of time talking with these folks. I think you're really going to get an excellent education and insight into the trajectory of what is really a hot area of mass torts and class actions and this intersection of bankruptcy. So I'm super excited to be joined by really amazing folks on this subject. I'll start down at the end with Melanie Cyganowski, who is a former bankruptcy judge in the Eastern District of New York and now attorney with Otterbourg and has experience across the bankruptcy landscape. Then we have Robert Stark of Brown Rudnick, who is head of their bankruptcy and restructuring group. I probably assume those names. And then we have Josh Sussberg of Kirkland, Ellis, who's on their executive committee and a partner in their restructuring group. And then I'm joined by Meghji, who is of M3 and has a tremendous amount of experience in very high-level bankruptcies, but is relatively new to the mass tort space. If I can out you a little bit there, but that's okay because we're going to tell him what he's in for, and it's a lot. There's a lot of exciting things happening. So we're going to start, maybe not at the beginning, but we're going to jump into some of the biggest cases that are happening right now, just to give you a sense of what are we talking about when we talk about the intersection of mass torts and bankruptcy, and what are some of the issues that are in these cases. So let's kick it off. Josh and Will, we'll start with you because you were involved in some of these. So let's talk a little bit about, and these are all talc related, I should the Whittaker case. And Josh, do you want to kind of kick us off and tell us a little bit about what we're seeing in that case?
Yeah, and full disclosure, Kirkland's representing Whittaker, Clark, Daniels. Mo is the chief restructuring officer. These are 4 companies that no longer are operational, that have historic talc liability. They've been weaving their way through the court system, dealing with judgments, dealing with pending litigation, and there's a finite set of assets that remain, whether it's insurance coverage and cash. And I think the thinking was, we got involved, that in order to have an appropriate distribution to the beneficiaries of these claims, it made the most sense to try to do this in one form, as opposed to creating incentives for people to raise the judgments and collect what is a small remaining amount of assets. And so we commenced Chapter 11 cases for each of the subsidiaries. In addition to the talc liabilities, there are also environmental liabilities that we'll need to address during the course of the Chapter 11 process. We've appointed a future claimants representative. We are certain that there will be a couple committees appointed in the case. And our thesis all along was that we want to engage in a meaningful dialogue and try to get people that deserve money, that money as quickly as we possibly can. I don't know, did I get anything wrong?
Yeah, I think you covered it all. The only other thing I'd say is no operations ever since these companies were even acquired. So I think it's really all about claims resolution.
So Robert, what are we seeing in the Revlon case, which is slightly different?
Can you sort of? Good. Let's just do this first. There's a line. Bad guys. Good. You represent creditors. You represent the campaign. All right. So Revlon, we represent.
Don't want to pay.
One. So we got to settle. We got to settle.
That's
right. Already ready.
Let's stay the fight. Yes. Revlon. I represent the partners community. Revlon. It's beauty stuff. It had lots of problems. Oops. Yeah. Had this LBO from the 80s, people may have heard of. And then the Perlman family, they never took any money out of it, right? But they used the stock as collateral to borrow more and more and more as they went to build out bigger and bigger and bigger, right? So what do you do when your stock is collateral for lots and lots and lots of loans? You want to make sure that even though you should be in bankruptcy probably 2 years earlier, you want to put off that bankruptcy as long as possible. So Revlon's bankruptcy, it has tort attributes, and very important ones. It was a good old-fashioned bankruptcy in the classic sense. It's a very simple business. You need a lot of help. You didn't know what to do with that business. Right? Should Revlon be broken up in certain pieces? Should reorganize? There's lots of fighting amongst the various forms of creditors. I represent the creditors committee. Mostly, usually creditors committees, it's sort of like a second. I do it as sort of a second order of directors of the company. We both sit on different aisles of the table.
Definitely disagree.
We're the ones without any power. But it's usually the 7 largest creditors. We had one of our creditors leave or go out, so it's 6, board of 6. It's not very functional. But 2 out of the 6 were whistleblowing claims from cosmetic talent. So we had lots of issues from a dynamic perspective of the community as well. We got it all resolved in actually fairly quick time, a year, a little bit shy of a year. That's pretty quick for a case of that magnitude of license.
Awesome, thank you. And Melanie, talk a little bit about LTL 1.0 2.0.
So you may or may not know the LTL case, but you will know it when I call it by the acronym Johnson & Johnson. So LTL is the subsidiary of Johnson & Johnson, and we'll speak in a few minutes about the so-called Texas two-step, which is what brought LTL to bankruptcy. But the genesis of LTL was frankly in the MDL. There's an MDL, there is an MDL that's pending in the District of New Jersey. To have the date in front of me, because the dates are important in these cases. October 14th, 2021, only 3 days after the Texas two-step was undertaken by this company, LTL filed actually in North Carolina. At that time, we became active with the MDL plaintiffs, and we fought to get the case transferred from North Carolina to New Jersey, which we succeeded in doing. It then went to the bankruptcy court in New Jersey. We had preliminary injunction hearings, which the company won. We then had a motion to dismiss, which the company won. And then it went to the Third Circuit. We went up on direct certification. And on January 30th of this year, the Third Circuit reversed and sent down the ruling by mandamus that the bankruptcy court should dismiss the case. On April 4, 2023, 2 o'clock in the afternoon, the order of dismissal was entered by the bankruptcy court. I didn't even get a chance to go to the restroom that day because at 4 o'clock, 4:11 to be precise, LTL2 was filed in the district, in the bankruptcy court in New Jersey. So it's been pending LTL2, aka Johnson & Johnson. It's been pending since April 4th. We've had a ton of things going on. We've had preliminary injunction hearing, we have a motion to dismiss. But it's just an incredibly complex case that's continuing.
Safety first, you don't succeed, try again. So you'll notice that none of these folks are senators on this panel, at least not yet. We were going to be talking to one, but things don't always work out quite as planned. But why did this group come together in its place, and why Talc, and why talk about these issues? And I think there's a really interesting, as I mentioned before, story brewing in the intersection of this. And Robert, I'd love your take on why is this even relevant for us to talk about?
Sure. So Johnson & Johnson's producing baby powder. We all got a little swallow bag when we tried to get children from the hospital. Filling your medicine cabinets. Ooh, thank you. Filling your medicine cabinets with Johnson & Johnson, that person for tear duct writing forever, right? That's motherhood, apple pie, and American flag is Johnson & Johnson. Since the 1950s, they've done this asbestos on top of it. Trace, hard to do, but when you actually have talcum on, in the talc is naturally forming asbestos and has to be removed. It's a purification process. And the issues have long been for decades as to whether or not asbestos that was in the talc powder actually was removed. Okay. And there was no statistical epidemiological connectivity between people with manifesting disease and talc usage up until very, very, very recently. Asbestos was around because lots of problems because people were beneath them. They were plumbers, they smoked. There were other issues that sort of intervened that created the talc problems initially in the 80s, I guess. And then it would surface for different reasons in the 2000s. We thought that was pretty much done. Okay. So therefore, it was very, very difficult for somebody who was actually trying a case against Johnson & Johnson to prevail in a case against them. You could not prove loss causation suits. And so actually, very, very recently, Johnson & Johnson was in court, in bankruptcy court, saying, we don't want you to resolve our talc issues here. We feel much safer in the tort system. We welcome the tort system. Okay. Things changed. 2018, in Canada, their version of the FDA issues a study, a very big study that says, we find statistically significant people getting cancer and the use of talc, those in women who marry cancer too. There's mesothelioma, they can actually do an autopsy to find talc powder as well. So it's much less directly there than it was in those CNS cancers. Okay? But that was the first step. Then, under a lot of pressure, the FDA in 2019 came out and said, we agree. Canada was lobbying like crazy. You're wrong, you're wrong, you're wrong. And they reaffirmed the statistical significance of China in 2021. So now you have a mass change of CMEC. The epidemiological studies are out there now by government-sponsored, independent folks saying that there's something this amount of that, this amount of that. And the tort bar gets invested. So they started looking into this more. And more money was invested, and more claims were getting from it. Most of the claims have failed up until this point in time. Loss causation was not easily proven in court. And all of a sudden, things began to change as the governments began to take a different view. Then you had the Ingram settlement, the Ingram judgment.
All right, the Ingram judgment in Missouri, and this is the one you may have read about, where it was a $2 billion judgment, went up to the Supreme Court unsuccessfully for Johnson & Johnson, and was following denial of cert that J&J began to look for other alternatives, and that led to this so-called Texas two-step. So from a policy perspective, and I know you guys aren't bankruptcy lawyers, but to try to put this in perspective, I'm probably oversimplifying it, but not by a whole lot. Up until these cases, with the COVID, you lose track of time, so since 2021, so the last 2 years, which has been for us a very little 2 years. Up until this point in time, for the most part, the companies that filed for bankruptcy had problems, just like Josh and just talked about with Whittaker and what Robert said about Revlon. You had failed businesses, or you had a limited amount of money with facing a large amount of exposure. Both LTL and, with due respect to Josh, who's debtors counsel and Arrow, which is the 3M case pending in Indiana, the view from the talc claimant's point of view is that these cases have been manufactured to take advantage of the tremendous and frankly very powerful weapons that we had in bankruptcy court. I like to think of it, and when I teach it, I talk about the quiver of arrows that we have in our back pocket that are fundamental to how we run a bankruptcy process and how we emerge with a plan of reorganization that is essentially a new contract as between the debtor and all the parties in interest with the debtor. In these cases, we feel that they parse out the bad, throw us, because I'm part of the bad, throw us into bankruptcy and then keep the good. So what happened in this Texas two-step for LTL was they took JJCI, which had Band-Aids, Tylenol, all the wonderful products that J&J has that are very fruitful and profitable. They spun those into one company, and they put all the talc claimants, all the talc liability into what we also call BADCO, which is LTL, Legacy Talc Liabilities. And they threw the LTL part into bankruptcy while all the good part is continuing. And that business is running fine, it's running the way it always did, the creditors get paid, Johnson & Johnson is making money, and all the talc claimants are in bankruptcy, and together with the bankruptcy is the request for an injunction, which is stay all of the litigation in the state courts. So if there were any there were no class actions, because there's mass courts, there's no classes, right? So instead we have the MDLs are stayed, and the state court litigation is stayed.
Yeah, just to double click on that so people appreciate it. So Johnson & Johnson, there's a divisive merger statute. That's what this Texas two-step is in Texas that allowed them to create a different company and push the liabilities into that company. Arrow, which is a subsidiary of 3M and has always been a subsidiary of 3M, is home to a earplug claims and all liabilities associated therewith. So there was not a divisive merger in that case. And Whittaker, Clark, and Daniels, legacy businesses, no divisive merger, very finite set of assets. I think in the first two, right, the issue and ultimately what was concluded by the Third Circuit is that Johnson & Johnson came in and gave a funding agreement to the subsidiary that had all the liabilities. And it was $60 billion funding agreement. And the Third Circuit said in that case, this is not a good faith bankruptcy filing because you have unlimited funds. And Johnson & Johnson's come in here, backstop $60 billion, and they're effectively just trying to cap liabilities. Can't do that. 3M and Arrow, and it's being adjudicated as we speak, so I don't want to get into specifics. Different set of facts and circumstances, but I think it's emblematic of the commentary that you're hearing, which is mass torts right across the board, whether it's talc, whether it's opioid, the Purdue Pharma case, whether it's general asbestos claims. There are ways to reach a resolution during the course of a bankruptcy case. And I think all of us up here are true believers in the bankruptcy system, but there are nuances and differences from all of our perspectives, just like anybody. All depends on where you sit. But there are ways in which things can be accomplished. And we'll talk about this on a more expedited basis, because at the end of the day, I believe from a company perspective, and I know you agree with this, it's our job to get the rightful folks that are entitled to the money in their pockets as soon as humanly possible. And it's not being righteous, it's just being right. And I think that's how we approach these cases. And I think there are ways in which the bankruptcy system can help properly adjudicate and ultimately deliver value to people that have real specific claims and damage.
So I'll just jump in, and from a business standpoint, a Revlon where you have an ongoing underlying business is one situation, which is really where you have natural liabilities that are in air quotes that have arisen out of the business versus an LTL, arguably being an Arrow. Whittaker has had no business. I think these are dormant companies that were liability runoffs that were required, probably in retrospect, not great investments. How do we, from the creditors, I guess the good guys' perspective, how do you view it that way? Where's the balance between protecting a business versus dealing with massive liability?
I'm going to let Robert do that, but what I wanted to come back to is I noticed just a couple stares, like, why do I care about this? I'm in class actions, and, I'm not in mass torts. What I basically want to share with you is you're not that different from where the mass tort lawyers were 2 years ago. It really doesn't matter. The point that we're trying to convey here is it really doesn't matter how healthy the defendant is, that is being sued in the class action. And what happens is you're doing your litigation, whether it's state court or federal court, and all of a sudden the bankruptcy, the defendant files, the company files. When that happens, just so you appreciate, you're out of business. I mean, you become the top claimants in our cases. It's just a very different paradigm, and just as the mass tort plaintiffs are struggling to find their way through the bankruptcy process, the same will happen to you. I mean, it just, what we're finding with these new cases, and we'll see whether or not the paradigm is successful. We're waiting, as Josh said, for the Second Circuit in Purdue. We're waiting for the Third Circuit. There's a writ of mandamus in LTL that they're looking at. In the Third Circuit, there's an appeal pending with respect to the preliminary injunction. But we'll see from the circuits if these cases survive, and if they do, then that'll make a huge difference for you guys as to whether or not you're looking at us next year as your counsel.
I think that's a really good point, Mr. Roberts. Sort of freaking, and I just wanted to poll the audience. How many folks are on the defense side? One?
Oh, so this is a point.
Well, you're on the good side of the group, I guess, then, for that.
I don't know which side does that fall on.
Yeah.
Right in the middle.
Plaintiffs side. Administration side. Everybody else does something in this space. Yes, okay. So Robert, go ahead. Sorry.
So, I love the question because it's hard, right? And I want to do this in all fairness, actually. I'm not 100% I actually think that bankruptcy is an interesting place where you can take these various stakeholders, whether it be towards or and actually sit and have a rational conversation over them. So I totally agree with you. But here's where it sort of becomes well hard for me. Where LTL kind of just takes our very dark corner of the universe, which people don't know anything about, and makes it just so absurd and hallucinogenic that I can't really survive.
Tell us how you really.
I'm always agree. When we walk outside the door every day, we don't think about a good to the hotel. We similarly don't think about when we walk on the sidewalk, we're not going to fall into the center of the earth. The car's not going to hit us. Or the food that we eat at the restaurant's not going to make us sick. Or the prescription drugs that we take, we ingest, are not going to make us our heads explode. Right? That this invisible bubble wrap, legal bubble wrap around our bodies, that enable us to go and live our lives and try to pursue happiness, that's what government does. And that all facets of government, from the regulatory apparatus to the criminal and tort law, protect us so we can feel comfortable living our lives, getting married, raising children, feel like that's a predictable way to proceed. Okay? My little world, my little dark corner of the universe is not part of pop culture. You don't hear about bankruptcy, Revlon bankruptcy in a movie, right? Like, there's nothing really all that fascinating about bankruptcy. We count the losses, we have the assets, we just it's kind of like,
Josh still wants to get a movie made.
yeah,
Something.
and he'll get But when some company, and Johnson Johnson's a good company, I'm not trying to vote for them, but when they take a legal tactic that punctures that bubble wrap around my kids, don't even focus on my kids' lives, like stuff that I've been feeling them, thinking that it was safe, that you marketed to me to make it safe, and I have no redress in courts. Because despite the Seventh Amendment that enables me to go to a jury of my peers and dare hurt my child, I can't go there because some fancy bankruptcy lawyer has done a gizmo to disable me from going to jury. Pisses me off on bankruptcy. I can only imagine now somebody who's, God forbid, is dying of ovarian cancer, never smoked, never was a pipe fitter, never had instances of asbestos in their life. What happened to be a runner and use talcum powder as part of the daily routine? The only possible place that they could interface with asbestos, and clearly it's a form of asbestos, right? But you can't get to a jury because some cockamamie bankruptcy lawyer in Texas has plugged the holes to make sure that you were deprived of your Seventh Amendment right. That should piss you off. And that's the problem. That's where it stops being That's what it's about. Counting the assets, making the liabilities the best we can, but the people who need money pay. It becomes more about a bunch of jerks. That's what
So, Josh, he wasn't talking about you. Did the Third Circuit puncture a hole in the Texas Tuesday bubble? Where do we stand on that?
Yeah, I mean, you ask any lawyer who's read the Third Circuit decision, you get a different answer. I think the Third Circuit entered an opinion that I think can be read narrowly and at the same time can be read more broadly. The Third Circuit had a problem with a $60 billion funding agreement and satisfying the bankruptcy code statute on good faith filing. The court went out of its way, and by the way, the Third Circuit judge that issued the opinion was a former bankruptcy lawyer in Delaware, who was very smart and very bright. And I think he left open the possibility, and it's going to play out in Johnson & Johnson too, that if there was more limited funding, then maybe you could survive a good faith filing test. Now, people turned around and said, wait a second, you had a $60 billion funding agreement. Now you've limited it to $8 billion. You just gave away, right, billions and billions and billions of dollars. How is that not, quote, the largest fraudulent transfer in the United States of American history? And that's something that's going to have to play out as well. But I do believe that there is a path for companies to file for bankruptcy and use the process to adjudicate and resolve these claims, notwithstanding the Third Circuit's decision.
And by the way, they gave away that $40+ billion in 2 hours and 1 minute.
4411, yeah, that 2 hours, yes, okay. So, and that is the financial distress test that you're kind of describing, is that's what the companies, so no, Josh calls you, you have to come in and help, and this is hypothetical, get a bankruptcy done, get a plan together for a company. There's some of these issues. You have to testify to the financial distress test under that framework. What do you argue fits the bill?
Well, look, a lot goes into that, but the fact of whether there's an ongoing business and whether these liabilities have come and remained in this company naturally versus it's a two-step process. All of that factors into that. That will be fought out here in the liability.
No, and I don't know if you.
Sure, the big question well, there are a few questions. Maybe the initial questions is whether or not LTL2 is in good faith. On the subclaimant side, we're obviously saying no. We're actually saying the value hasn't changed. I mean, whether or not the $60 billion is in the form of a funding agreement or in the form of a fraudulent conveyance that we'll try to undo, the bottom line from our point of view is the value is the same. And that if it wasn't financial distress in the first one, it really can't be in the second one. From the company's point of view, they're going to argue that, if they are arguing that the funding agreement was frustrated, their argument is that there's a frustration of purpose that was the direct result of the Third Circuit opinion. And the chief legal officer testified 2 weeks ago that when they read the Third Circuit opinion, they truly had not anticipated it, and no one could have anticipated that they would have been reversed, and therefore the funding agreement by its terms was frustrated and void or made voidable. And therefore, from their point of view, there was no fraudulent conveyance. They then abolished, eliminated the funding agreement, they voided it from a corporate perspective, and substituted it with another that was smaller in scope. So those are the arguments that will be playing out as the case completed.
But it's hard, like Johnson & Johnson 7, how many little SPV LTL. It's in the title. It's a Talc Liability. It's got no assets, it's got all the liabilities. And then they go to court and they come up with every reason that is like a bottom of their shoe as to why it's supposed to be genuine and it isn't to be all that for the client. Right? But Mo's right that it's a very hard situation, and poor Mo is going to the wolves and we're the wolves. When Josh calls him up and says, hey, it's not the binary LTL, one way or the other. It's more in the middle. It's not so overtly. It's just a little bit. It's a little bit. That's the thing about the opinion, and Josh is right. The Third Circuit's decision, written by a very smart bankruptcy judge, a bankruptcy lawyer, who's sitting there, who's experienced, we all sat and argued, the argument for a service agreement. And he said to the lawyers for well more than an hour, it's the longest appellate argument I've ever seen. I did good company, bad company restructurings in the 80s, the SNL crisis. Are you telling me that I was a bad faith lawyer? I thought I was doing something. And how he defined it in order to make it work was, you gotta show the bankruptcy judge that there's some financial distress. Then it goes on for a page and a half, saying, well, what does it mean to be in financial distress? I don't know. And I'm not gonna tell you. I'll tell you that you'll sort of know it when you see it. And as Mo kind of said, if the tort law stuff kind of defaults the bank stuff, or makes it unable to get liquidity, or nobody wants to buy your products, that probably is what it would be. But, there's a lot of chicanery going on the side where there's a lot of corporate stuff.
So there's motions to dismiss in a lot of these cases, pretty much.
Yeah.
When would you guys not bring a motion to dismiss? How do you look at it?
First.
When you have the paradigm of what I believe is LTL and in Arrow for different reasons, it's not a Texas two-step, as Josh said, but we did make the motion that was to dismiss, which is pending before the court, so I won't get into that right now either. But for cases that are of this ilk, I frankly have trouble with it from a bankruptcy point of view, because I don't think that you have the right, for want of better words, the right ingredients. You don't have the right dynamics. You don't have the financial distress element, which is something that brings parties together. I mean, what I believe is happening, and there's so many different layers to this. I think one of the things that's happening is that when people are in the MDL and the companies get frustrated with how the MDL is going, and in your instance, I would analogize it to they get frustrated with how the class action is going, that at that point they want to substitute forms. So you'll be reading and you're seeing a lot of articles that, and arguments in court that this is nothing more than a venue play, that the companies are trying to get to change the venues from wherever verdicts are not going in their favor, or the MDL or substitute the class action court is not ruling in their favor, and then coming to bankruptcy court. So I think there's a lot of distinction between Article 1 courts, which are the bankruptcy courts, and Article 3 courts, which are the federal district courts. That's also
Yeah, the one thing I'd say, and I think you said it well early on, which is, right, there are companies that clearly are financially distressed and have massive amounts of claims. Purdue Pharma was a good example of that. And then there's, Johnson & Johnson, which presumably could be on the other end of the spectrum. And, Mo, you're clicking on something important here, which is, yes, there are companies in between, but dependent upon how the courts rule in Johnson & Johnson and in Arrow, there are a massive amount of companies in the United States of America that are dealing on a daily basis with various types of litigation claims, environmental liabilities, opioid liabilities, whatever it may be. And dependent upon how these cases get ruled upon, there is a whole new world that could potentially be unlocked for companies to be able to deal with liabilities, not on a one-off basis, not in 60,000 courts across the United States of America, but in one potential bankruptcy court. And it's going to be different case by case, to be honest. And I know, everybody's got certain moves to the basket as to, we want to dismiss, we want to seek an injunction, and everybody thinks that there's some type of playbook. But the reality is every one of these companies is different. And dependent upon how Johnson & Johnson plays out, I think there's going to be a significant amount of activity to the extent the court determines and is found to be on appeal appropriate.
You mentioned the opioid cases. Is it worth talking about what's pending in the Second Circuit there?
Yeah, Purdue Pharma confirmed the Chapter 11 plan, and the Sackler family agreed to contribute through a mediated settlement $4.5 billion. There were tons of people on board, including 43 states, right?
Yes.
That you represented. So Attorney Generals, 43 states, everybody's on board. Bankruptcy judge said these people are contributing $4.5 billion. Of course, we're going to give them a release because we're not going to allow the people that are withholding and objecting to be able to pursue them for additional value, additional money. There was all sorts of speculation as to how much money was taken out. It was investigated up, down, left, right, center, all the way around. And the decision of the bankruptcy court was appealed to the district court, and the district court reversed it and basically said third-party release doesn't make sense. We believe the Sacklers contributed too little, and as a result, we're thwarting efforts to effect a settlement that, again, 43 states thought made sense to get money into opioid claimants' hands. And so that decision is pending at the Second Circuit. I think from a bankruptcy professional standpoint, it is very, very, very significant because if third-party releases are wholly unpermissible in a bankruptcy, and I know the standards have been, interwoven and migrated over time, but if someone's making a contribution and the court determines that there is a contribution and third-party releases are not permitted, it will make very difficult our ability to construct holistic resolutions that put money into various people's pockets that deserve it.
It's really important about that few more details. In order to get a plan like this done, we need a really high threshold of people in favor. So Josh is the master of this. He's the lead debtors lawyer in the country. And so he'll have cases where he's constructing a deal with this, cutting the stakeholders. And there'll be these massive influxes of money. If you can guarantee me a reversal, something to write a really big check. And most people won't want to do that. And the statute says, hey, if you've got a high enough threshold, it's less than 75%, those were wanted, you should allow that to happen. Okay? What the district court said, which I'm absolutely fascinated by, it's spending a lot of time thinking about this for a time, which is essentially, you're a crummy little bankruptcy court. Off in Westchester, New York. You're really an administrative law judge, not a big part of the 3 judges. Who are you to make health, safety, and welfare policies for the opioid addict in PO? And are the 3 judges, Congress, President, bankruptcy judges, not so much.
But delivering $4.5 billion,
But there's
still going to victims.
That's the problem. That's the problem in a nutshell. Because there's nothing better about $4.5 billion than $10 billion or $2 billion. None of us are solid. None of us know what the right number is. It's the power that comes with it. And that's what Judge McMahon had a problem with. She said, it doesn't matter what the people, she wanted her number. And so she said any number from a bankruptcy judge is inferior to her number, which is law unto itself. But the jurisdictional question is so important from what we do. I don't know how to sit and cut a deal with you people if I can't figure out how you can go and sell the contribution in. Right? And so I can't do my job by enabling you to do your job. So while we sit here and say, hey, we shouldn't give releases to bad people, then we can't get money to the people we represent too. The system unfolds.
It sounds like you guys
I want you to
are
remember
agree.
that when we meet tomorrow morning.
I'm attracted.
No, and from the bankruptcy judge's perspective, just to put my hand on from a number of years ago, I was honored to have sat as a judge for 14 years in the Eastern District. But from the judge's perspective, you know that there are, I'll call it bad guys in the case, but there does come a time when there's a deal to be made, that everything comes together before you. The question is, do you stand on legal principles and say, this is a technical violation of the code? Is at the end of the day, when the judge is confronting a plan, they have to make a finding that the plan that's presented to the court complies with all aspects of the bankruptcy code, whatever and everything that entails. So you know that you might be on the edge here, but when I can appreciate Judge Strayton feeling that I've got 49 billion, I've got 43 states, I have almost total unanimity of the hundreds of thousands of claimants that voted on the plan. The sole objecting party that went up on the circuit was the United States trustee. It was not a claimant other than the 7 states that were not part of the Avon consortium. So at that point, it's like, you know what, even if there's bad guys, it's time. It's time to pull this together. It's time to allow it to proceed and move on and move on. So there's all those tensions.
So Judge, how does this ever get resolved? Is it going to require legislation?
Well, that's what's interesting. I will be, we'll see what happens. If the Second Circuit upholds Judge McMahon and does not permit the third-party releases, I suspect it can only be done by legislation.
Supreme Court.
Well, the Supreme Court, our bet is more likely than not that they would uphold that. We don't see anything, most commentators don't see much within the Supreme Court that would say, yes, extend the reach to third parties. So I suspect it would be legislative, and if it's legislative, then we'll be waiting for a long time. Congress is being over.
So we only have a couple minutes left. Are there any questions from the audience? Ask these brilliant minds.
Just from a moral standpoint, the Texas two-step feels like, why can't any company who has one product that's not working, be allowed to separate that from a very successful company generally that has tons of money? I mean, I conceptually cannot bridge that gap in my brain.
That's a question.
Yeah.
Josh, that's for you. It's your morality in the corner.
So I think the way to think about it is, right, what these companies are trying to do is bring to conclusion an overall resolution settled. So they're not saying,
Why are they entitled to that?
but whether they're entitled to it or not, right, the question becomes, okay, you could pursue your claim, Robert can file his action in whatever state court he wants, and you can be rewarded because you went first. And at some point, the money is going to run out. And so we're not saying that people should get zero. We're saying we should do this in a justifiable way to get people as much as they can and create a settlement pot to pursue those claims both now and in the future. And so, to the extent it's determined that a divisive merger is upheld, then you can do that. It's not that you're saying it's zero, right? It's you're saying we want to deal with this all at one time.
But there's nothing wrong with that. Look, I obviously share what you just said, right? But Johnson & Johnson's case is just so awful and so ridiculous. But I think pretty much every, that's where a little bit more reminded of that. You kind of blew it on this one, Johnson & Johnson. A little bit less. The problem is that it's not that bankruptcy is bad. It's not that they created a special purpose vehicle to get into bankruptcy. That's not necessarily bad. What's bad is that if you're a person who's sick, you now have this 105 injunction that prevents you from going after not LTL, but Johnson & Johnson, one of 2 companies in the world that has a stronger credit rating than the United States government, has more money on its balance sheet in its bank accounts than anything else. It can afford to pay your verdict, right? But it's choosing not to, creating obviously paper mache arguments as to why it is that it should be getting the benefits of LTL. it's so drippy bad, right? And so it creates the great policy discussion because it's so drippy bad. But like more of Josh's work and Mo's work is really in that middle, where it's not the binary good guy, bad guy, right hand guy. And that's where actually, as committee and oriented as I am, I worry. I really do worry. But I understand why Judge McMahon kind of blew a gasket at Judge Lee. And I get it, right? Like, maybe you should just stick to counting the liabilities. That's leave the Article 3 stuff to some judges. I understand. But that's not really very practical. And at the end of the day, I take the guy at his face value. I've known him for a really long time. He's a really good lawyer. He's not tight. When he says he really does want to get money to the people who deserve it, he really does. The problem with the Texas two-step is that in order to create the dynamic to negotiate, you've got to send the victims to the gulag. They can never get to the jury as they're dying, as they're trying to prepare for their families. And the bankruptcy doesn't create milestones and other things that otherwise can post time limits. So when they say, we'll fund this forever, we got $61 billion available. Take your time, Judge. Be deliberative. Let's think about it. Let's spend 5 years in the gulag. Okay? If you're trying to take care of your family, that's a death sentence. And that's what makes it so unrivaled. And I don't think that's normally what we do.
No, and I did get the sense from all of you that there's an agreement, but you want to get to a resolution, right? That's the end goal, right? But- So, not, well, right.
They'll
We're
go
not-
out 5 more times.
certain cases aside, yes. So, all right, we're gonna get yanked off the stage for a second here. 30 seconds each at most. What's the next future state? What's the next tap, or what's the future for this type of case? Big thing to watch. Go down the line.
To everyone's point, I think we're all watching what the circuits are going to do, whether it's the tension between the MDL courts and bankruptcy courts, or bankruptcy courts and Texas two-steps. If the two-step is upheld, if the process that is unfolding right now in mass courts continues, I think we'll see the Monsantos and other major companies who are facing huge liabilities considering the potential of bankruptcy, just so they can bring it all to one forum and ideally find a way to resolve all the issues.
Monsanto's the memory list. From local memories. But I can only imagine what the environmental comes over these issues. This can really tell you about it too, so there's lots of
Lots of
John?
I mean, pick your favorite tort that's come out of the system. Wrappers at fast food restaurants, right? That have all sorts of potential liabilities. Roundup, other yard products. There's an endless amount of litigation, class actions throughout this country through a definitely aggressive plan storm. And to the extent that Third Circuit determines that what Johnson & Johnson did was appropriate in certain circumstances when you could identify financial distress, I think the floodgates will.
No, final word.
No, look, I would say that kind of the judgments on Purdue and LTL and Joint Cyganowski will have a huge impact. I think so.
All right, well, we will be watching for your predictions. Thank you all so much. Thank you for your time.